And
okay, this is interesting. But I think we're going back to his qualifications as someone who is able to testify on all of this cell phone messaging and stuff. Because he's been angry about this since yesterday. That this guy has no foundation. He hasn't established any credentials that in any way qualify him to make any comments regarding any of the collection, the analysis, or the authenticity of the documents of the texts themselves. So he's a little bit animated, and he's continuing it in the afternoon session. Apparently, he didn't have a good lunch yesterday.
Creating reversible error. When Detective Moretti was deposed on February of 2021, he indicated that he's not an expert. That's why the FBI was called to testify on these records. In addition to that, he went on to say,
hold on. All right. Extend, counsel, the same courtesy you expect but not to be interrupted. All right?
Whoa.
Go ahead.
he went on to testify under oath that when you look at these chats, it's coming from one phone to another phone, correct? His answer, correct. And if I have your phone, for instance, I could chat with, and I use Mr. Haddad as an example because he was in the deposition. He said, correct. And by looking at your phone, you would think that you sent Haddad that nasty message, like whatever, correct, correct. He goes on to say, in other words, would you be able to make the statement that one person received a call from Melly? And he goes, no. He goes on and testifies. The question is, well, two people are speaking to each other, but one of them would have to verify that he's the person who responded or wrote the message, correct? And he says, legally, yes, sir. Mm-hmm. They have not authenticated one of these messages. They know it. He's not qualified to do that. They have to call one of the parties to authenticate it. That's why, with all due respect, we have been interrupting, coming sidebar constantly on all of these messages. They are leading, the state is leading you astray on this because they have not authenticated one message. And now they're attributing it to Williams talking to Melly, Melly talking to Williams, and that can't, there's no predicate for it. And even the witness knows that. So we would be objecting to all of this and willing to strike it all.
Oh, and he's absolutely correct.
Just to play that forward logically, the way that counsel is arguing, if a witness is dead, there would never be a communication that would be in evidence.
No, that is not correct. If you've got a dead guy, and if you've got a guy who doesn't want to testify about the authenticity, you bring the engineers from the phone company to explain how this happens, to explain the process, to explain how these are authentic texts. That's how you authenticate them. You don't, it's not, there's no way of introducing this evidence if somebody's dead. That's a stupid assertion to make, Ms. Prosecutor. That's dumb. That's why they have these, the phone company guys who come in and testify, ad nauseum about really boring stuff solely for the purpose of saying these are authentic text messages coming from this person to this person's phone. She's being disingenuous. The prosecution is spot on here, and I agree with him.
So in terms of the way counsel is arguing that is contrary to the evidence code on that. The state, and that goes to weight, not admissibility. This evidence is admissible. It is statements of the defendant that has been established over and over and over again that he was the person using the 772-713-9007 phone. He is the one who's taking all the pictures on it. He's the one who's giving the password to his mother. He's the one who has to.
Did I say prosecution? I agree with the defense, not the prosecution.
Video of his underage girlfriend. This is not a phone that's being passed around to multiple people, and there's no evidence to support that. In fact, what the evidence shows, and in every video that you've seen of the defendant, he's walking around with a phone in his hand. And the state would submit to you and to this court that it has well proven the defendant himself in the statement on the jail call.
That's incorrect. She just said everything, every video we've shown shows him walking around with the cell phone in his hand. Bull, you just showed a video of a woman shooting a video of him. Not everyone. I've told you a million times, prosecutor, don't exaggerate. Come on. Now I'm getting annoyed. She's doing this shit again. She's doing it again. The prosecution is now, they're exaggerating. They're being disingenuous. And she knows what she's doing. She's not ignorant about this. And she just said, oh, yeah, every video we've shown, he was walking around with the video in his hand. Literally the very last video you showed contradicts that statement. Knock it off, prosecution. Do it right or don't do it at all. I think I may have misspoke and said prosecution earlier. I meant defense. The defense is absolutely correct in their arguments.
Calling the 772-713-9007 phone number is saying that is his phone. In addition, Your Honor, the state has provided case law previously that a item can be authenticated by the contents of the item itself. That is clearly what we have in this, that the contents of this phone authenticated and show it to be what the state says it is, which is statements of the defendant and statements of the victim, in this case, Anthony Williams, and with the rest of them are the other statements of the co-defendant and the defendant and his girlfriend, where she's putting, and there's internal parts of each of those that can be authenticated.
Hold on.
Parts of each of those, the defendant and his girlfriend, where she's putting, and there's internal parts of each of those that can be authenticated. Girlfriend that have
Wait, what?
That the contents of this phone authenticated and show it to be what the state says it is, which is statements of the defendant and statements of the victim, in this case, Anthony Williams, and with the rest of them are the other statements of the co-defendant and the defendant and his girlfriend, where she's putting, and there's internal parts of each of those that can be authenticated.
Yes, there are internal parts that can be authenticated, and you need to do it. You need to authenticate them, not this cop on the stand who doesn't know anything.
There are 3 ways to really authenticate a text message: the receiver, the sender, and if you don't have either one of them, then you call the engineering.
Right, exactly.
To show that the text messages are in fact true and correct.
Exactly.
For them to say they could never get a text message in if a person is deceased is absolutely not true. They would need, if they don't have the receiver, the sender, then they have to call the engineering company from Sprint, T-Mobile, whoever it is, to show how the messages are extracted from the phone, not the detective. And more importantly, this detective has already admitted he's never been declared an expert in any of this. And that's why the FBI was called in.
So I may clarify on that.
Can't say it better than he said it.
Context, because that was with regards to the T-Mobile. Counsel's conflating the difference between information from the cellular networks and information from the phone itself. They are separate and apart. They're 2 different sources of data and 2 different sources with which the evidence in this case is being drawn from. Counsel is trying to confuse them and using parts of the depot from the T-Mobile to try and say that it would apply to other sections, which is completely inappropriate and a misrepresentation of what actually happened in the definition. In addition, the detective, when he first got up and testified, he talked about his training experience in Celebrite, Cellhawk, and all the different phone and cellular phone specific evidence classes and certifications of which he was.
I got to go with the defense. The
One
defense
last
is
comment, John.
absolutely correct, I believe.
She has introduced 500 and some odd pictures, a whole bunch of text messages over our objection, a jail call. So if anything, this is all cumulative if the court doesn't agree with what this witness, this detective testified under oath, that he's not an expert and you have to get a message in, either receiver, sender, or there is case law to say the engineering company as to how they can extract a message. I will give them a 3rd alternative. They've done none of that in any of this.
Preach. Preach, Mr. Defense Lawyer.
All right. We'll be in recess. Thank you.